Good morning. This is your Kelso Report for Tuesday, April 3rd, and I'm your host, Clark Kelso. Well, the Supreme Court gave us a couple of cases yesterday, one search and seizure, the other dealing with absolute immunity, and it granted cert in an immigration case and in a takings case. From the Ninth Circuit, we've got an affirmative action holding, habeas corpus, and a case involving disability benefits. And finally, we closed the California Court of Appeal in a bail forfeiture case. Let's start with the Supreme Court. Search and seizure, a certainly controversial case, I think, for many people, although I think in the law it's a pretty straightforward issue that the court has decided, and it decided it rather narrowly. The extent to which jailers can conduct an invasive search, essentially a strip search, of persons arrested for minor offenses was before the court in Florence v. Board of Chosen Freeholders of County of Burlington. The petitioner was arrested during a traffic stop by a New Jersey state trooper who checked a statewide computer database and found a bench warrant issued for petitioner's arrest after he failed to appear at a hearing to enforce a fine. Part of the booking process at jail involved a mandatory shower with a delousing agent, being checked for scars, marks, tattoos, and contraband, having an officer examine his ears, nose, mouth, hair, scalp, fingers, hands, armpits, and other body openings, opening his mouth and lifting his tongue, and lifting his genitals. He ultimately was released when it was discovered he actually had paid the fine. Oops. He then sued under Section 1983, asserting that the search violated his 4th and 14th Amendment rights. Writing for a bare 5-justice majority, Justice Kennedy rejected the claim, holding that jailers have a reasonable responsibility to preserve the safety and order of their facilities, and that the searches here did not go beyond what was necessary to serve those interests. The facts did not involve a body cavity search. Instead, as described by Justice Kennedy, in broad terms, the controversy concerns whether every detainee who will be admitted to the general population in the jail may be required to undergo a close visual inspection while undressed. Noting that jails admit some 13 million persons a year, the court reasoned that maintaining safety and order requires the expertise of correctional officials who must have substantial discretion to devise reasonable solutions to the problems they face. As a general matter, a regulation impinging on an inmate's constitutional rights must be upheld if it is reasonably related to legitimate penological interests. Concurring separately, Justices Roberts and Alito emphasized that the holding was limited to situations where an arrestee was being committed to the general population portion of the jail facility, since the interests in safety and order primarily related to management of the general population. The dissenters, led by Justice Breyer, argued that a full search, such as that conducted in this case, should be permitted only if the officers have a reasonable basis for thinking that a particular arrestee may present a danger to other detainees or members of the jail staff. But the majority, I think quite rightly, found that standard impractical and unworkable for correctional officers to administer. The court's decision is clearly not a comfortable one, even for the majority, and it expressly reserved the question for another day of whether it is always reasonable, without regard to the offense or the reason for detention, to strip search an arrestee before the arrestee's detention has been reviewed by a judicial officer. So I have a feeling the court is not done with strip searches of persons arrested on minor offenses. Next, we have a case involving absolute immunity. The chief investigator for a district attorney's office testified in a grand jury proceeding that resulted in the plaintiff's indictment. After the indictments were dismissed, the plaintiff brought an action under Section 1983 alleging that the chief investigator had conspired to present and did present false testimony to the grand jury. But applying well-established immunity doctrines, the Supreme Court unanimously held in Rayberg v. Polk that the chief investigator was protected by an absolute immunity from suit for testimony delivered to a grand jury. An absolute immunity already protects witnesses at trial, and the court rejected the plaintiff's argument that grand jury witnesses should be treated as so-called complaining witnesses instead of as trial witnesses. The court rejected this argument because a so-called complaining witness historically didn't really even testify as a witness. Instead, the term referred to anyone who procured an arrest or initiated a prosecution as a practical matter. The law was clear that if a complaining witness actually did testify, well, that witness received the same absolute immunity as other witnesses. The court extended the doctrine to grand jury testimony. Next, we have a cert grant in the immigration context. In Moncrief v. Holder, the 11th Circuit had held that a conviction for possession of marijuana with intent to distribute qualifies as a felony drug offense under the Controlled Substance Act, and therefore makes a lawful permanent resident removable. The court has granted review, I think, to determine whether the 11th Circuit's reading of the removability statutes is accurate. And the court also granted cert in a takings case. In Arkansas Fish and Game Commission versus United States, on an in-bank denial, a panel of the Federal Circuit held that flooding due to government action must be a permanent invasion before a landowner can recover damages for a takings of his or her property. Now, there was a strong dissent to the denial of the in-bank petition in the Federal Circuit, which note that this holding is contrary to the general approach, which requires a more nuanced examination of the frequency, duration, and harm caused by government-induced flooding. The Supreme Court will, I think, in this case have to decide whether flooding that is a predictable consequence of federal government conduct, but is temporary each time it occurs, can be a takings, even though the flooding is not permanent. Next, we turn to the 9th Circuit. The constitutionality of Proposition 209, the Anti-Affirmative Action Initiative, was before the court in Coalition to Defend Affirmative Action versus Brown. And the panel rejected the equal protection challenge to Prop 209's ban on affirmative action in public education, holding that it was bound to follow its prior decision upholding Proposition 209, about 10-12 years ago. The plaintiffs had argued that the court was free to reject its prior decision because of the intervening decision by the United States Supreme Court in Grutter versus Bollinger. But Grutter was easily distinguished by the 9th Circuit, since Grutter held only that affirmative action was permissible under the Equal Protection Clause, not that it was mandatory. The panel's holding on the merits was unanimous. Judge Tashima dissented from the panel's conclusion that the president of the University of California, Mark Yudof, could be sued for prospective relief under the Ex parte Young doctrine. Next, we have two habeas decisions from the 9th Circuit. First, in Wenzel versus Nevin, the petitioner's pro se habeas petition appeared on its face to be filed beyond the 1-year limitation period, and therefore was untimely. The district court sua sponte dismissed the petition on this ground. Now, the rule is well established that when untimeliness is obvious on the face of a habeas petition, the district court has the authority to raise the statute of limitations sua sponte and to dismiss on that ground. But it is also well established that that authority should only be exercised after the court provides the petitioner with adequate notice and an opportunity to respond. The 9th Circuit also held that this particular petition was not a second or successive petition. The defendant had been convicted of multiple crimes and sentenced. He then filed a first habeas petition. After that petition was filed, the state courts reversed one of his convictions, and he was resentenced. The 9th Circuit held that in these circumstances, a habeas petition challenging the second sentencing is not a second or successive petition. This holding is in harmony with the rule in the 2nd Circuit, but is contrary to a holding in the 5th Circuit. So we have a nice conflict between the circuits on a fairly straightforward issue, dealing with the proper administration of habeas corpus. Just the sort of thing the Supreme Court likes to review So don't be surprised if Wenzel versus Nevin goes up to the court next year. The second habeas case. The defendant was convicted of murder in 1986 and sentenced to death. In 2008, the district court granted habeas relief as to the defendant on his claim of ineffective assistance of counsel during the penalty phase of trial, vacated the capital sentence, and ordered a retrial as to the sentence or the imposition of a life sentence without the possibility of parole. The government did not appeal that decision. The defendant, however, appealed the denial of his request for an evidentiary hearing on his claim of ineffective assistance of counsel during the guilt phase of his bifurcated trial. Now, because the government does not argue that trial counsel was effective, the only question related to prejudice. In Ben Shalom v. Ayers, the Ninth Circuit concluded that the district court did not err in declining to order an evidentiary hearing because the defendant cannot establish prejudice from counsel's ineffective performance under the Strickland standard. The evidence before the jury was substantial, including 2 unequivocal confessions. In light of the evidence the defendant now argues should have been presented regarding a mental state defense did not undermine confidence in the jury's finding of guilt. Next, in the area of disability benefits, the district court in Molina v. Estrue affirmed the decision of the Social Security Commissioner denying the petitioner's application for disability insurance benefits. The petitioner argues on appeal that the administrative law judge erred by giving inadequate weight to the opinions of her primary care provider, by improperly determining she was not credible, and by rejecting the testimony of her family members without comment. Well, the Ninth Circuit panel reviewed the record closely under its Social Security cases and concluded that the ALJ did not err in weighing the evidence or in finding the petitioner's testimony was not credible. Although the ALJ erred in failing to give germane reasons for rejecting some lay witness testimony, that was a harmless error, and the ALJ's reasons for rejecting her testimony applied with equal force to the lay testimony. So the court affirmed. Next, we go to a bail forfeiture case. The defendant was arrested and bail in the amount of $50,000 was posted. The defendant fled to India. An agent of the bail bondsman located him in India and the district attorney was informed. Now, under the law, if the district attorney fails to seek extradition, the bail is exonerated. In this case, however, the district attorney sought extradition through appropriate diplomatic channels. Unfortunately, this is a time-consuming process, and the time passed for the defendant's appearance. So the trial court entered summary judgment on the bail in the people's favor, and the bail bondsman appealed. In People v. Western Insurance Company, the 5th District affirmed the trial court's judgment, rejecting Western Insurance Company's argument that the appearance period for the criminal defendant who fled to India should have been equitably told during the extradition process. After examining the statutes dealing with bail, and noting that Western already had been the beneficiary of a statutory extension for cause, the court held as a matter of law that equitable tolling is not applicable to the bail bond forfeiture statutory scheme. Bad news for the bail bond industry with respect to defendants who successfully flee the country, since, even if the defendant is located, extradition is never a quick process. I can well imagine the industry may approach the California legislature with a bill to deal with cases where the defendant has been located in a foreign country and the only remaining delay in returning is attributable to the extradition process. And that's it for today's Kelso Report. Have a great day in the law.